Hello, today we're going to be talking about effective communication requirements from the ADA and what this looks like in different ADA cases and across different types of disabilities.
Any materials provided by Washington Civil and Disability Advocate, WACDA, are for informational purposes only and are not legal advice. WACDA is not responsible for the consequences of your reliance on any informational materials provided. Your use of informational materials does not create an attorney-client relationship or any other relationship or the expectation of confidentiality between you and WACDA. Views expressed in informational materials are those of the individual author and may not reflect the views of WACDA or its individual staff members. If you need legal advice, you must seek advice from an attorney regarding specific legal issues. For the general laws and regulations found in the ADA regarding effective communication, we have the general standard for effective communication found in the Code of Federal Regulations that reads, "A public entity shall take appropriate steps to ensure that communications with applicants, participants, members of the public, and companions with disabilities are as effective as communications with others." A public entity would be a local or state government and their agencies, such as schools, courthouses, libraries, etc. In terms of auxiliary aids and devices, a public accommodation shall furnish appropriate auxiliary aids and services where necessary to ensure effective communication with individuals with disabilities. A public accommodation is any business that is open to the general public, so like a restaurant, a store, or a movie theater. When public entities or public accommodations are thinking about what kind of auxiliary aids they need to provide for public entities, they must give a primary choice to the individual with the disability and their preferences. For public accommodations, they're encouraged but not required to give primary consideration to individual preferences. They can choose what to provide, but it must be effective and provide effective communication according to the regulations. In terms of captioning, one place we see that a lot is on screens, especially on movie theaters or TV screens. So in terms of movie theaters, there are actually recent extensive regulations about what kind of auxiliary aids and captioning need to be provided in movie theaters. So auxiliary aids are mandated in the ADA to prevent discrimination, as we just talked about. In movie theaters, closed captioning is required. And closed captioning is when captions are provided on a personal device. The number of devices required to be available depends on the number of auditoriums available in a theater, but the theater must provide them upon request, as well as audio description devices, which I will talk about in a few slides. Open captioning is when the captions appear on the main screen for all viewers to see. This is not required, but may be used as a substitute to closed captionings. Per 2017 regulations, movie theaters must provide captioning when provided by film distributors. For the standard theater with 8 to 15 auditoriums, there needs to be 8 closed captioning devices, and it's proportional to how many auditoriums there are. Per the new 2017 regulations, movie theaters must provide captioning when it's provided by film distributors, but they're not required to create their own captions when a film distributor does not provide them. That's the Johnson case on the slide. In terms of stadium captioning, this case, Innis versus Board of Regents of Maryland, so that's actually a public entity because it's a public university. In this case, the plaintiffs had vision impairments. The stadium offered handheld captioning devices, but they were realistically ineffective in the game setting because, first of all, the sun was too bright, so the people couldn't read the captions, and also if you have to look down at the captions, you can't be interacting with other people or really fully enjoying the game. It's not the same experience, so it was actually ineffective. The court held that the stadium had to give primary consideration to the individual requests. So while the public entities are not required to make structural changes to existing facilities, they need to change their methods if they're not effective. Also, individuals must have access to game-related information broadcast over public address systems in both the Stadium Bowl and the concourse areas. This case was covered by Title II, which required them to make reasonable accommodations to remove barriers to communication.
A final case about captioning has to do with captioning for transportation hubs. In Dobart versus San Francisco Bay Area Rapid Transit, the problem was that the local rapid transit system with buses and trains was providing a lot of audio information about when trains were arriving and which trains would be delayed or canceled without providing captions so that people who couldn't hear that information could still effectively use the trains. This case found that the San Francisco BART system was required to create captions for this information so that people would have access to the information that they needed to ride public transportation. This is also important for people who don't have hearing disabilities, but who are at a crowded, loud train station. And so this access accommodation can make things more accessible for everyone.
This picture is an example of a closed captioning device in a movie theater setting.
Another type of effective communication case is the case for people who need to use sign language to effectively communicate with others. The first case listed, United States EEOC versus UPS Supply Chain Solutions, is a case involving employer-provided interpreters for an employee. The employee in this case didn't have good written comprehension of English because ASL was his native language, and during complicated meetings, the notes that he was given were not complete, and he couldn't give feedback or ask questions in meetings, which was impacting his ability to do his job. And so the court found that the system of passing notes was not effective communication in this case, and his employer, UPS, had to provide a sign language interpreter for the important weekly meetings where the communication was most complex. Another case about interpreters is Duffy versus Rivland, which involves interpreters in prison. A deaf man who was in prison had several hearings in the prison, and those disciplinary hearings, because they affected how long he was staying in prison and whether or not he would, for example, be placed in solitary confinement, having an interpreter there was very important for him. And this case also specified that an employee who was somewhat trained in ASL but did not have any interpretation experience and did not have a full ASL vocabulary would not be an effective substitute for an actual interpreter, especially because of how sensitive these meetings were. KM versus Tustin Unified School District is an IDEA case. For more about IDEA, see our video previously, but this case compared IDEA and ADA guidelines for interpreters. IDEA, when it comes to cost, does not allow an undue burden defense in most cases, but only requires as much communication support as is necessary for an appropriate education, which does not always include interpreters. The ADA, on the other hand, has an undue burden framework, which means that schools have to spend a lot less money and have a defense that this cost would be too high. But the ADA requires effective communication, which for public entities can be a much higher bar. And so in this case, a child who could hear some of the class through an augmented hearing device, but was requesting an interpreter because that would allow this child to hear more of the class, was not able to get an interpreter under IDEA, but was under the ADA. And this is an example of the interplay between different disability laws that are similar but have some different requirements. The Armstrong versus Davis case is a complex court case that covers several different issues and is going to come up again. But regarding people who use sign language, this case ruled that the court forms used by the state of California were not accessible to people who use ASL in their daily lives and required an ASL translation of written English that's coming up in court. So not just what people are saying, but also if someone is given a form to sign or paperwork to acknowledge, that requires an ASL translation as well, because people who use ASL don't always have a high level of comprehension of written English because it's a different language.
The next case is Akins versus St. Helena Hospital. This case was of a deaf woman who uses sign language, and her husband had an emergency and had to go into the emergency room at a hospital, and she wasn't able to communicate with the doctors concerning her husband's care because no one there could understand her because she used sign language. The court in that case ruled that a public accommodation such as a hospital may not require someone to provide their own translator. In fact, they need to provide a way to consistently communicate with people who use sign language on site.
One of the ways that hospitals use interpretation to consistently provide effective communication is through video remote interpreting. Video remote interpreting, or VRI, is a type of interpretation service where a hearing person will speak aloud, an interpreter on a remote video will translate that spoken English into ASL, and the deaf person in the room will be able to watch the video of the interpreter and understand what's going on. There are some important guidelines for VRI in medical settings. A lot of those guidelines are technical requirements for how good the video system has to be, but some of the requirements are that there is a smooth, constant translation, that the interpreters in the video relay are trained, that medical staff is trained in how to use VRI, and that VRI shouldn't be used for certain medical situations. For example, in highly complex cases, for minors, for people with limited communication ability because of the medical situation happening, or for people who use a sign language other than ASL. In all of these cases, instead of VRI, a medical setting should request and use a live interpreter. Title IV of the ADA also creates another type of system for people who use sign language. It creates both a TTY and a VRS system. These are both analogous to a telephone system and are not substitutes for VRI, but a TTY is a text-based communication where people type into a machine which then sends that message across telephone wires. And VRS is a video chat system that is similar to a web chat system like Skype that allows deaf people to use the telephone system to call each other and then speak to each other using sign language. Both of these were set up by Title IV of the ADA and require telephone service, but neither of them involves an interpreter, and so neither of them is appropriate for communication between people, one of whom is hearing and one of whom is not.
This slide has links to videos showing how VRI can be helpful in medical and emergency settings. If you'd like, you can pause this video and take a moment to watch how this technology works in the field. These links are also in the description of the video.
Another type of situation where effective communication is important is for people who have difficulty hearing in loud environments. In some cases, assistive listening devices can be used as an accommodation. There are a few different types of assistive listening devices that amplify the sound being spoken so that someone can hear it. A few major examples include FM broadcast systems, which are a short-range microphone system that functions on radio waves and so can accidentally be overlaid with another signal if something else in the vicinity is trying to use the same radio frequency. Infrared microphone systems, which must be used within a sight line of the infrared system, but because it's based on infrared light, it cannot be overlaid with other signals in the area and tends to be very clear. Audio induction is another type of microphone system that sends signals over Wi-Fi straight to someone's hearing aids so that someone can use that internet connection to hear what's coming through a microphone. And generally that works in a single room, so the microphone isn't attached to a particular person, but to the room in general. Other accommodations for people who have difficulty hearing in loud environments include noise dampening techniques like architectural changes or screens to keep out outside noises, and the provision of material in alternate formats like exchanging written notes of verbal instructions so that the information is backed up by a format that does not require strong hearing.
Now we're going to talk about some cases that concern people with vision disabilities. First case is Robles versus Domino's Pizza, and this is a fun modern case. It came out in 2019 about website accessibility, and in that case the Ninth Circuit ruled that a website and an app is actually part of a public accommodation, and it's part of what needs to be effectively communicated. So being accessible to people that are blind or have vision disabilities is part of effective communication and required by a public accommodation, even on a website or an app. Audio descriptions in theaters. So we talked a little bit about how closed captioning is required, and audio description devices are also required. Every theater must have a minimum of one fully operational device for every 2 auditoriums. Audio description devices are designed for people who have difficulty seeing the screen, and they're also called descriptive narration devices, and they're spoken narration of a movie's key visual elements such as the action, the settings, the facial expressions, costumes, and scene changes. So they help people fully enjoy the movie.
Another aspect of the case Armstrong versus Davis had to do with the provision of readers in court settings, because people with vision disabilities were often expected to read and sign lengthy court documents. It was a failure of the California system to require them to do so without someone who could read that document to them, so that they're actually taking the information from the court documents that they're signing. People with cognitive and communication disabilities are also an important demographic when you're thinking about effective communication. Just because the issue isn't a physical one doesn't mean it's not covered by the ADA. Armstrong versus Davis covered this very effectively because of the large number of people with cognitive disabilities in the class action in this case. And the court required the forms that they were being given to be simplified and explained and sometimes put in alternate formats so that people who are going through court in the state of California can actually understand what's happening and can actually make substantive decisions about their actions in court. This accommodation is very important, especially in a criminal court setting, because people with cognitive disabilities are overrepresented as criminal defendants and often have a difficult time dealing with court cases if their forms and communication with bailiffs and judges and other officers of the court is not provided to them in a way that they understand. In Washington state, we have a statute that has to do with communication in court because of the intense constitutional issues with effective communication in court. RCW 7.69b.020 requires that disabled people and other vulnerable populations like minors have to have access to information happening in court. People who are in court who have disabilities or other situations that mean they might not understand what's happening have to be provided with a greater level of care so that effective communication is happening. We don't want people going through the court process, not understanding what's going on, and unable to participate in their own case.
Thank you for listening to this presentation. We hope you found it helpful. In the description, there are links to the Department of Justice fact sheet and guidance for effective communication.
There's also a guide from the Alliance for Equal Justice to accessibility in the Washington state courts and different ways to make court more accessible, which can also be a model for people working in other states.
There's also a website from the National Association of the Deaf that explains video relay interpretation regulations.